Abraham, you ready?
Yes, Your Honor.
All right, so Mr. Schmidt's ready to go?
Yes, Your Honor.
Good afternoon, Mr. Schmidt.
Howdy, Judge.
Who would you like first, sir?
Katie Wilson. Come on down, Katie.
Right, so it looks like Ms. Wilson today charged on an ag assault, deadly weapon, first degree felony. Gonna be pleading to a lesser included class A misdemeanor assault. Family member. 124 days, county jail, credit for all time served. $100 fine, court cost, reimbursement fees, is that right, Mr. Schmidt?
Correct.
Okay, Ms. Wilson, if you'll raise your right hand, I'm gonna place you on oath.
Yep.
And Ms. Wilson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Ms. Wilson, you're kind of soft spoken, so just speak up loudly, clearly for us, okay?
Okay.
Thank you. Ms. Wilson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
You are currently represented by Mr. Richard Schmidt, your attorney. Are you pleased with him as your attorney?
Yes, sir.
You feel like you've had enough time to talk with Mr. Schmidt about your case to the point where you understand everything about your case. You've had all of your legal questions answered, and you don't have any questions about the paperwork that you've read over and signed today. Is all of that right?
Yes, sir.
All right, Mr. Schmidt, do you believe Ms. Wilson to be competent?
Judge, I do, and previously as a court clerk, I did file a motion just incompetency and asked for her to be evaluated, which she has been. Dr. Ingram has returned his report and ruled her competent. I've met with her several times after that report was returned, and we were able to effectively communicate. So as of today, the answer is yes.
And you believe that she's entering into this plea today intentionally, knowingly, and voluntarily?
I do, Judge.
All right, Ms. Wilson, you were indicted with the first degree felony offense of aggravated assault of a family member or household member with a weapon. However, today you would be pleading to a lesser included offense, a class A misdemeanor assault causes bodily injury of a family member. That does have a range of punishment of not more than 1 year in the county jail and a potential fine not to exceed $4,000. I see that your plea agreement today, as I read earlier on the record, fits within that legal range of punishment. Understanding that, Ms. Wilson, do you still wish to go forward with the plea today?
Yes, Your Honor.
All right, then Ms. Wilson, how do you plead to assault causes bodily injury of the family member?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime for no other reason?
Yes, sir.
All right, court does accept Ms. Wilson's plea of guilty this time. Mr. Schmidt, any objections to the stipulation of evidence?
No objection, Judge.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No, sir.
All right, court's going to review the stipulation.
Your Honor, I do have one. Mr. Schmidt had needed a correction to it, so I have one that it's not signed by him or Ms. Wilson, but it's signed by me.
Can you just read the stipulation into the record?
Yes, Your Honor. On or about November 28th, 2022, in Van Zandt County, I, Katie Wilson, got into a physical altercation with Glenda Vance, who is a member of my family. During that altercation, I caused an injury to her arm.
All right. Based on the court's review of the evidence presented, the court finds that there is sufficient evidence to convict Ms. Wilson of this offense. The court does follow the plea agreement today, convicts Katie Lillian Wilson of assault causes bodily injury of a family member of a class A misdemeanor. assesses her punishment at 124 days confinement in the county jail. Issues her credit for 124 days of time already served. Court does order her to pay a $100 fine, $270 court costs, $585 in reimbursement. Ms. Wilson, when you are released from the jail, if it's before 5 p.m., I want you to come over and come up to the clerk's office, make arrangements to pay your fines, court costs, reimbursement fees. You can't pay all of those today, then we'll need to talk to them about payment. You understand?
Yes, sir.
Ms. Wilson, if it's after 5 p.m., for some reason, if you get released after 5 and the courthouse is closed, then just come up here next week as soon as you can. Okay? Then you go ahead, Mr. Schmidt.
Yeah, just so the court's aware, Ms. Wilson has a misdemeanor hold out of Wood County, so it's highly likely she'll be transferred over there to attend to that business real quick. And I've advised her that when she's finally released, that she needs to come to the courthouse and make arrangements to pay those fines and fees.
Thank you, sir. I appreciate that. All right, Ms. Wilson, you're hereby remanded to the custody of the sheriff, so you can carry out the terms and conditions of the sentence. Step over with the deputy. Who did you want next?
Actually, though,
All right, Mr. Over. This is file number CR 21-59. Mr. Over, you raise your right hand on the oath. Mr. Over, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. All right, Mr. Over, you're here today on a motion to adjudicate your guilt from a probation plea. It looks like you were last court on the original charge on October 14th, 2021. You appeared in court, you pled guilty to a state jail felony possession of a controlled substance. Court heard the evidence on that day, but followed a plea agreement that you reached with the state. The court did not convict you, placed you on community supervision for 3 years and ordered you to pay a $3,000 fine. During your period of community supervision, the state filed a motion to adjudicate and revoke on February 8th, 2022. In that motion, it appears that the state has alleged 7 separate counts of violations. Ms. Dover, have you had enough time to review that document with your attorney, Mr. Schmidt?
Yes, sir.
If you have any questions about any of the plea papers that you signed here today with Mr. Schmidt?
No, sir.
Are you pleased with Mr. Schmidt's work as your attorney?
Yes, sir.
All right, Mr. Schmidt, if you believe Ms. Dover is competent in carrying into this agreement, intentionally voluntarily.
yes, sir.
All right, and does she intend to play true to all 7 counts?
Yes, sir. We wait for reading and enter plea true to all counts.
All right, thank you, Mr. Schmidt. All right, Mr. Dover, then at this time, I'm going to ask you, how do you plead to counts 1, 2, 3, 4, 5, 6, and 7? Are those counts true or not true?
True.
And you're telling me that each one of those are true because in fact they are true. You're not just saying that to get a plea agreement, is that correct?
Yes, sir.
All right, the court will accept Ms. Dover's plea of true to each count as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights to plea of truth?
No objection.
That is admitted, the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Okay.
All right, then based on the evidence before the court finds that Ms. Dover has violated the terms and conditions of her community supervision. The court finds all 7 counts alleged in the state's motion to be true. Court hereby follows the plea agreements reached between Ms. Dover and the state. The court adjudicates the guilt and convicts Ms. Ashley Faye Dover of possession of a controlled substance, penalty group 1 less than 1 gram. The court revokes community supervision, assesses her punishment at 12 months confinement. Texas Department of Criminal Justice State Jail Division orders her to pay the balance of her financial obligations. The court awards her 255 days credit towards her sentence for the time she has spent jail on this cause. Ms. Dover, Once you are released from prison, it's important that you report to the courthouse and make arrangements to pay your fines, court costs, and restitution. This over hereby remanded to the custody of the sheriffs who can carry the terms and conditions of the sentence. Please send it over to the deputy to review. Who's next, Mr. Smith?
Rel Dugan,
Mr. Dugan, CR 16473, state versus Rel Dre Dugan. Am I saying that middle name right? Is it Dre?
yes, sir.
Okay, good. All right, Mr. Dugan, if you will raise your right hand, sir, place you under oath. Mr. Dugan, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, so you go again. Mr. Dugan, you appeared before the court previously and entered into a plea agreement on April 11th of 2019. Court finds that you appeared and pled guilty to possession of a controlled substance, penalty group 3, a third-degree felony. Court heard the evidence following the plea agreement that day. Court did not convict you, rather placed you on community supervision for 8 years and assessed a $2,500 fine. During your period of community supervision, the probation department filed a motion to adjudicate and then a secondary known as amended motion to adjudicate on June 1st, 2023. And they've alleged what appears to be Mr. Schmidt, do you have, I'm missing counts 3 through 7 on my paper. Do you have counts 3 through 7 as well?
Judge.
You do, okay, so there are actually a total of 11 counts.
That is correct.
Okay, so Mr. Dugan, the state has alleged 11 separate violations.
No, Judge, I'm sorry. I take it back. Those Roman numerals threw me off. I see 1, 2, 8, 9, 10, and 11 on my motion. And that may just be a numbering issue with the Roman numerals.
Now, let me look at the original file here.
The judgment has 6 separate violations.
Leading you to believe that it's just a numbering issue on
I
the
do,
side.
Judge. I believe that it's just a Roman numeral problem. Ultimately, the judgment reflects the same number of violations on the motion.
And Your Honor, in my file, I have the same numbering issue.
Well, let me throw another monkey wrench. In the original filing, there does appear to be a count 3, 4, 5, 6, 7, and a page 2. Let me display that. Don't choose. That's this appears to be. Let me make sure I'm gonna get the right one. Amended 1 file June 1st. Count 3 is transfer fees, count 4 community service, count 5 drug education, count 6 alcohol drug val, count 7 law offense. We need to take some time to regroup on this one, Mr. Schmidt, to make sure, one, that your client's aware of all these allegations, to see how he wants to plead, and to correct the judgment to make sure that it matches the plea agreement.
Well, Judge, and as far as I know, based on my review of the motion, I disregard the the numbering, and so I believe it was 1, 2, 3, 4, 5, 6 counts that the state had alleged. And I believe that's what my copy in my office states as well. Dugan was prepared to plead true to those 6 counts, and those 6 counts are likewise reflected in the judgment. The numbering, though, wouldn't, in other words, we would plead true for the sake of keeping it on track to counts 1, 2, 8, 9, 10, and 11.
1, 2, 8, 9, 10, and 11.
Correct.
Just assure me again what the second page of the judgment says.
The judgment says that the court finds that the defendant violated his terms of community supervision in the amended motion to adjudicate condition D, M3, A, and A.
Well, I think what Mr. Schmidt is indicating that his client is willing to do is plead true to counts 1, 2, 8, 9, 10, 11, which would mean that I need to know what the state's intentions are to do with regard to count 3, 4, 5, 6, and 7.
Yes, Your Honor, and state would abandon counts 3, 4, 5, 6, and 7.
Okay, that's good. All right. You, Mr. Dugan, need more time, Mr. Schmidt, are you ready?
I believe we're ready to proceed, Judge.
Okay. All right, so Mr. Dugan, the state has alleged it appears to be 11 separate counts. However, here today that the state is going to abandon counts 3, 4, 5, 6, and 7. It looks like the plea agreement today is that upon your plea of true to those, state is going to recommend that your guilt be adjudicated, you be convicted of the offense, your community supervision be revoked, you be sentenced to prison for 3 years, ordered to pay the balance of your fines, restitution, court costs, and you would receive 345 days credit towards that 3-year sentence for time that you have already spent in jail on this case. Is that your intention and what you're asking the court to approve today, Mr. Dugan?
So,
Yeah, Mr. Dugan, have you ever, I think we've already talked about this as far as mental health, we've done those things. As far as today, Mr. Schmidt's representation, are you pleased with Mr. Schmidt and work he's done for you?
yes, sir.
You understand everything that you've read and signed and you don't have any more questions, is that correct?
Yes, sir.
All right, Mr. Schmidt, I'm not sure if I would ask or not, but you believe Mr. Dugan confident in entering into this plea intentionally going involuntarily?
I do.
All right, and Mr. Dugan, Mr. Schmidt, does Mr. Dugan waive the formal reading of the motion?
We do wait, Judge.
All right, Mr. Dugan, the court requires as to how you plead to counts 1, 2, 1, 2, 8, 9, 10, and 11. For those counts, if that's true or not true. And you're telling me that each one of those are true because what is alleged is in fact true. That no one's threatened you, forced you, or pressured you to plead true. Is that correct?
Yes, sir.
All right, the court will accept the defendant's plea of true to counts 1, 2, 8, 9, 10, and 11. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights to plead true?
No objection.
That's submitted and the court takes judicial notice of Mr. Dugan's judicial finish. Anything further from the state?
No, Your Honor.
Anything further from defense?
No, sir.
All right, and based on the evidence presented, the court finds that Mr. Darrell Dre Dugan has violated the terms and conditions of his community supervision. The court finds counts 1, 2, 8, 9, 10, 11 to be true. Court follows the plea agreement today. Court adjudicates Mr. Dugan's guilt, convicts him of possession of a controlled substance, 20-degree, third-degree felony, assesses his punishment at 3 years confinement, Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, including fines, restitution, and court costs. The court awards Mr. Dugan 345 days credit towards his sentence for the time he spent in jail on this cause. Mr. Dugan, you hereby remain into the custody of the sheriff, so carry out the terms and conditions of the sentence. When you get out of jail, I need you to report to the courthouse, call the courthouse, and make arrangements to pay your fines, restitution, court costs. You can't pay them all on the same day. You can make a payment arrangement. Failure to follow through with one of those things, paying it all or getting a payment plan, is going to result in court issuing you warrant for your arrest. Do you understand?
So,
All right, thank you, Mr. Dugan. Please step over with the deputy. Thanks, Mr. Schmidt.
Joshua Hand.
Joshua Ray Hand, CR 21-168. Mr. Hand, if you'll raise your right hand, place you on oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, thank you, so you can raise your hand. Mr. Hand, are you pleased with Mr. Schmidt and the work he's done for you as your attorney?
Yes, sir.
You had enough time to review the state's amended motion to revoke, and you understand everything that's been read over and signed, is that correct?
I do, yes, sir.
And Mr. Schmidt, you believe Mr. Schmidt to be competent in entering into this agreement and swing knowingly and voluntarily?
Yes, sir.
All right, court finds Mr. Hand appeared before the court on March 8th, 2022. He was convicted by plea agreement of the offense of evading arrest for detention of the vehicle. Sentence was assessed that day at 10 years confinement in prison. However, the court suspended that sentence, placed Mr. Hand on community supervision for 10 years. On the recommendation of the state, it was during that period of community supervision that the state filed its amended motion to revoke and had alleged appears to be 13 separate counts. Mr. Schmidt, does Mr. Hand waive the formal reading of the motion as he intended to all counts?
Yes, sir.
All right, Mr. Hand. I see that the plea agreement today is immediately true to all counts. The state's recommendation is that the court revoke your community supervision, assess punishment today at 5 years confinement in prison, ordering you to pay your fines, court costs, reimbursements, restitution, and you receiving 116 days credit to your sentence. Is that your understanding of the agreement?
Yes, sir.
All right, any questions about that before we go forward?
No, sir.
All right, then Mr. Hand, how do you plead to counts 1 through 13?
Sure, Your Honor.
And you're telling me that all 13 counts are true because they are in fact true, and that no one's threatened, force, or pressure you to plead true to those, is that correct?
Yes, sir.
All right, the court will accept the defendant's plea of truth in each count as alleged. There should be any objection to the defendant's waiver of rights, if they are true.
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
No, sir.
All right, based on the evidence presented to the court finds that Mr. Joshua Ray Hand has violated the terms and conditions of his community supervision. Court finds all 13 counts to be true. Based on that finding, the court revokes the defendant's community supervision, assesses his punishment at 5 years confinement, Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 116 days confinement credit for time he's already finished. Mr. Hand, once you are released from prison, you need to make arrangements to pay off the remaining fines, court costs, other fees. Failure to do so will result in the court issuing a warrant for your arrest. Get out, okay?
Yes, sir.
All right, and you remain in custody of the sheriff, so you carry out the terms and conditions of the sentence. Please step over to deputy. Who's next? Wooden?
Yes, Zachary Wood.
CR 22-55, State versus Zachary Taylor. What's the announcement on Mr. Wood?
Judge, from Ms. Curry, I spoke to Mr. Wooten on Monday, but we haven't spoken since. We still need a little extra time, to get his business resolved. And we'd ask that this be reset.
Any objection to the statement?
No, Your Honor.
All right, board will set Mr. Wooten for a final hearing on the state's motion on October 26th. At 1:30. Sorry, that was also being called under CR 2256. All right, who do you have now?
This is Mr.
All right, this is cause number CR 19-10. Say there's James Lopez Felixto. Sure there was some evidentiary hearings today.
Judge, we're on the state's motion to revoke community supervision. We're gonna have to earn an official setting on Mr. Calixto so I can continue to talk to the state.
Any objection to the statement?
No.
All right, court will set for a final hearing on the motion October 26th at 1:30. It's who you have this down?
Billy Schultz.
All right, this is cause number CR 21-243, say versus Billy Joe Schultz. And note that we are pleading Mr. Schultz, is that correct?
That is correct, Judge.
All right, Mr. Schultz, sir, raise your right hand and place your left. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you lawyer again. You have to make sure you speak up loudly and clearly for me so I can get it through the computer so I can hear
Judge, Judge, I'm sorry to interrupt. Can we recall Mr. Schultz?
Yes, sir. No problem.
Right.
Yes, sir.
Are you ready?
Are you ready on your screen?
Judge, ready on Mr. Hogue, Mason Hogue?
Oh,
Yes, Judge.
all right, this is cause number CR 22-76, State versus Mason Gregory Poe. Motion to revoke, I believe.
Yes, Judge. I was appointed on Mr. Hogue's case yesterday. I've had an opportunity to go over the motion with him. However, I have not had a chance to discuss that with the state. I request that we be reset for us to negotiate and see where we're going to go with this case.
All right, court will set Mr. Poe for a hearing on October 26th. That'll be a contested hearing. Mr. Amini, of course, as you're aware, practicing in this court, if you reach some kind of agreement with the state to resolve the case prior to the 26th, let us know. We'll get you set over here.
Yes, Judge. Next, I got Mr. Watkins.
Michael Watkins, CR 20-201.
Judge, I got appointed to Mr. Pogue Friday after I'd already done my jail visits. I have not had an opportunity to speak to Mr. Watkins prior to today, but I have spoke to his wife, who is been working with me up until 12:45 today. trying to get medical records to provide to the state. Mr. Watkins has several nerve degenerative diseases that are real serious. And so we're looking to do this as an expedited resolution. I need to get with the state once I get the medical records and see if we can come up with some type of resolution. I have a couple options after speaking to my client today. So we'd request a shorter reset on this one, just so we can keep that on the top of the docket.
Okay, let's do this. We're going to give it 2 settings. We'll set it for October 12th. That's a Thursday. Figure that's the earliest one I can get you on a Thursday. I can get you on a Tuesday before that. So do you want the ticket on 10/12, and then we go ahead and set it for the test hearing on the 26th as well?
Perfect, Judge. That'll keep it online. So. Sure.
Who's next?
Judge, next we have Mr. Pugh, Dylan.
DR 23-170, State versus Dylan Pugh.
Judge, I don't know if you have the paperwork or not. This is gonna be a class A misdemeanor.
Yeah, I think I do have it here. Thank you. All right, Mr. Pugh, if you raise your right hand on a place your oath, sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Honor.
All right, your name is Dylan James Pugh, is that correct?
Sir.
Mr. Pugh, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Sir.
And is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Looks like a plea agreement you have with the state. It is today you plead guilty to a class A misdemeanor offense, assault causes bodily injury. The state's recommendation is that you be convicted of that offense and assessed a sentence of 48 days in county jail with credit for time served, no fine, court costs of $270, reimbursement fees of $515. Is that your understanding of the plea?
Yes, sir.
Mr. Manning, do you believe Mr. Pugh to be competent, and if so, that he's entering into this agreement intentionally, knowingly, and voluntarily?
I do, Judge.
You explained to Mr. Pugh the consequences of his plea as they relate to this type of offense.
I'm sorry, you cut out there right at the end.
It's okay. I said, and you've explained to Mr. Pugh the consequences of this type of plea.
I have, Judge.
Okay.
And Judge, if we may, when the time's appropriate, I would like to call my client on a couple issues.
Yes. All right. Well, why don't you go ahead and call him at this time?
Perfect, Judge. Mr. Pugh, I've been representing you since you were appointed counsel in this case. Is that correct? Yes, sir. And you've been in jail for how long? 48 days. Okay. And during that course in time, we've had opportunity to discuss your case as well as possible defenses to that case, which was originally charged as an aggravated assault. Is that correct? Yes, sir. Okay. And you understand that by going forward this plea today, you're waiving those defenses that we discussed in order to take this deal and be done with this case. You understand that? And you understand that this conviction will go on your record. You won't have an opportunity to get it expunged or anything, but once convicted of a class A assault, that will follow you the rest of your life. Yes, sir. Your Honor, I pass the witness.
State, any questions?
No questions, Your Honor.
All right, thank you. All right, so Mr. Pugh, the range of punishment for a class A misdemeanor is potential confinement up to a maximum 365 days in the county jail and a fine not to exceed $4,000 if imposed. Let me ask for a point of clarification here. And this is a class A assault, non-family violence, correct?
That is correct, Judge.
And court does find that the recommended sentence does fall within the range of punishment. So, Mr. Pugh, I would ask you at this time, how do you plead to assault causes bodily injury?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime for no other reason?
Yes, sir.
All right, court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
Judge, no objection to my client's admission of guilt. I don't believe we've been provided with a formal stipulation of evidence for review, as it is a class A misdemeanor.
All right, court accepting the defendant's plea of guilt. Let me ask you, Mr. Pugh, has anybody pressured you, forced you, did anything make you feel like you had to plead guilty to this crime?
No, sir.
All right, state does accept the defendant's plea of guilt, takes judicial notice of his judicial confession. Anything further from the state?
Your Honor, just since this is an assault case, our office made attempts to reach out to the victim, calling the last known number. We were unsuccessful with our attempts, but we have made those attempts as part of this process.
Okay, and let me just clarify. I'm not sure why I'm fuzzy on this, but tell me why this is a class A misdemeanor, not a class B misdemeanor.
Your Honor, my understanding is that a class B misdemeanor would involve strictly sports participants. I believe any assault bodily injury is a class A. And then as far as like family violence would go, that would just be an additional finding as well as the class A.
That is correct.
All right, thank you, counsel. All right, anything further from the defense?
Nothing from defense.
All right, and based on the evidence presented and court taking the judicial notice of Mr. Pugh's judicial confession, court hereby convicts Dylan James Pugh of class A misdemeanor assault causes bodily injury, assesses his punishment at 48 days confinement in the county jail, issues credit for time served 48 days, orders him to pay a $270 court cost, $550 reimbursement. Mr. Pugh, when you are released from the jail, you need to report to the courthouse, to the district clerk's office, to make arrangements to pay your court costs and reimbursement fees. You can't pay them all at once. You need to talk to them about a payment plan. Failure to do so will result in the court issuing a warrant for your arrest. We'll go back to this process. Understand?
And Judge, if I may, now that there's not a collections office, who would he be speaking to? Would it be the district clerk or the court coordinator?
District clerk.
Okay, and I have instructed him as such, but I was trying to clarify for the record.
Yes, district clerk. I think they're the only ones with statutory authority to collect. All right, Mr. Pugh, you hereby remain into the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy. So all you have, Mr. Minnie, if you have it.
Judge, I have two more. I'm still waiting on the paperwork on Mr. Ozuna.
Who are you ready on now?
Judge, ready on Burton.
Corbin Chase Burton, CR 2390, CR 2391. Mr. Burton, if you'll raise your right hand, place you under oath, sir, do you swear that the testimony you give before will be the truth, the whole truth, and nothing but the truth, so help me God?
Yes, sir.
All right, Glory. Mr. Manning, are we still proceeding with a plea in each one of these cases?
I'm sorry, did you cut out right there at the?
Yeah, are we still proceeding with a plea in each one of these cases?
We are, Judge. The issue with paperwork has been resolved. I was able to go over that with my client. Additionally, Judge, he has signed the supplement regarding chapter 62 and has received a copy of that in both cases.
Great, thank you, Mr. Manning. All right, Mr. Burton, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you are represented by Mr. Manning, your attorney. Are you pleased with his work for you as a lawyer?
Yes, sir.
And the paperwork that you've read over today is, do you have any questions about that, or do you understand everything that you've read and signed?
I understand.
Okay. Mr. Manning, do you believe Mr. Burton to be competent, and if so, that he is entering into this, to both of these plea agreements intentionally, knowingly, voluntarily?
Judge, I do believe him to be competent. He has been able to assist in his defense since the very beginning. I believe that is intentionally, no only involuntarily.
All right. Mr. Burton, cause number CR 2390 and CR 2391, you've been indicted with the second-degree felony offense of sexual assault of a child. Each one of those does carry a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a potential fine not to exceed $10,000. I see that the plea agreement in each case is that upon your plea guilty, state is agreeing to abandon its enhancement paragraph in CR 2390. Recommend to the court that your punishment be assessed at 10 years confinement in prison with a $1,000 fine, court costs, reimbursement fees, and 245 days in jail with as credits. The court finds that the plea agreements are the same in each case and recommended to run consecutively. Mr. Burton, is that your understanding of the agreement and what you're asking for to approve?
Yes, sir.
All right. All right, Mr. Meany, is there only one enhancement paragraph? Is there not an enhancement in CR 2391?
No, Judge, there's not.
Okay, all right, very well. Okay, understanding the range of punishment and understanding the agreement, this time, Mr. Burton, I would ask you, how do you plead to sexual assault of a child in each cause?
True, Your Honor.
You be guilty or not?
Guilty.
Are you pleading guilty to each one of these crimes because you are in fact guilty of committing these crimes?
Yes, sir.
And Mr. Burton, has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
Or does accept the defendant's plea of guilty this time? Mr. Maney, any objection to the stipulation of evidence?
Judge, it's not a strictly material objection, but I would like to note that in both of the stipulations of evidence, it has some extraneous language that my client says is not true. And like I said, it's not material to these facts. So we'd ask that those be struck, specifically that there were other children present in the house during the alleged dates. And so, like I said, that's not strictly relevant to these proceedings. My client would ask that that be struck from the stipulation of evidence.
State.
Your Honor, I can draft new ones and send them out to the jail for signatures.
Okay, so there is a motion to modify the stipulation of evidence to exclude the what? The words watching my children and other children to bed.
That's correct, Judge.
Okay. Anything further from the defense attorney?
Nothing in regards to stipulation of evidence, Judge. I would ask, and this is, I haven't done one of these in a while, but the language in CR 2390 regarding the consecutive sentence, I'm not sure how TDJ requires that, but the way it reads is kind of circular. It says that the sentence in 90 will not begin until the judgment is ceased in 91 and vice versa. I don't know if that's statutorily required or if we need to clarify that he'll be doing 90 first and then 91 will be consecutive to that. I pointed that out at the last setting, but I don't know if they're just following a particular form that has to be done by TDC.
So your recommendation is to omit consecutively from 90, place or consecutively in 91.
That's correct. I think that makes more logical sense. But like I said, I don't know if they're following a form that's made by TDC. I didn't have time to research that once I got the paperwork this afternoon.
I know that in a matter of practice, when it comes to the word concurrently, which is 180 degrees different than what we're talking about consecutively, with concurrently, I know it's common practice to put them both in there so that there is no question about whether something's consecutive or not. State, do you have any objection or any information whether or not the state's following in preparing these judgments, is following statutory requirement for
Yes, Your Honor, our understanding is that it is mandated, that language be in there.
That each sentence runs consecutive to the other one.
Yes, Your Honor, I'm not 100% sure of the logic of it myself, other than our understanding is that, it's mandated that it be in both.
Mr. Manning, do you want to stop and just research this issue?
Judge, I believe, I just had an opportunity to speak to my law partner, and I believe that he confirmed what the state had said, that is, for whatever reasons, statutory required. So I'm fine with going forward as long as we're following the language that is mandated through the statute and the TDC.
Okay. All right, so we're ready to proceed.
Yes, Judge.
All right, then, I believe the court's already, have I admitted the stipulation of evidence, Mr. Manning? We talked about that, I did.
Judge, I believe we have not, we're waiting on a corrected stipulation based on my client's request to amend.
Okay. Is there any objection to the amended stipulation of evidence? Where the court acknowledges the defendant's request to change regarding the presence of other children? Is there any objection to that being amended into the record?
No objection, Judge.
All right, court admits the amended stipulation of evidence. Mr. Hartwell, if you'll make sure it says amended stipulation of evidence.
Yes, sir.
Court also takes judicial notice of Mr. Burke's judicial confession in each case. Is there anything further from the state, Mr. Hartwell?
No, Your Honor.
Is there no victim impact statements or? I've got victim impact statements on other cases, but not on this case.
Yes, Your Honor, let me, I'm getting into the case now, and stipulations, I'll double check on that. Your Honor, I see that victim impact statements were provided but not returned.
All right, thank you, Mr. Hartwell. All right, then based on the, is there anything further from the defense, Mr. Manning?
Nothing from the defense, Judge.
All right, based on the evidence presented to the court and the amended stipulation of evidence, the court finds that there is sufficient evidence to convict Mr. Corbin Chase Burton of each one of these offenses. The court in cause number CR 23-90 convicts Corbin Chase Burton of sexual assault of a child, assesses his punishment at 10 years confinement, Texas Department of Criminal Justice, Institutional Division. Orders that the sentence run consecutively with cause number CR 23-00091. Court also orders a $1,000 fine, court costs of $290 and reimbursement fees of $20, and awards Mr. Burton 245 days credit towards this cause. Cause number CR 2391, the state convicts Corbin Chase Burton of sexual assault of a child. Court following plea agreements assesses punishment in accordance with the plea agreement. Also at 10 years confinement, Texas Department of Criminal Justice, Institutional Division, a $1,000 fine, $290 court costs. And the court orders the sentence to run consecutively with cost of CR 23-90, of course, for 245 days credit. Towards the sentence for time spent in jail on this cause. Court finds that Mr. Burton is prosecuted and convicted pursuant to chapter 62 of the Texas Code of Procedure. The court finds that each one of these offenses requires admonishments regarding sex offender requirements, or finds Mr. Burton has received said admonishments and also received a copy of chapter 55 Texas Code of Procedure. And Mr. Burton, you hereby remanded to the custody of the sheriff so that he can carry out terms and conditions of the sentence. Please step over to be fingerprinted with the Mr. Manning. You're step away.
Judge, Ellis said we're still waiting on paperwork for Ozuna, so I'll yield the floor to Mr. Schmidt.
Okay, hang on just a second, Mr. Manning.
Yes, Judge.
I got a question for you. I was looking at CR 2391 on Mr. Burton. And it looks like stipulation of evidence. Each case has the same offense date.
No, Judge, it has, on the judgment, they had the same offense date, but on the stipulation of evidence, it's different offense dates. The stipulation of evidence is the correct offense date. One was July 1st and one was July 16th, I believe.
So where does January 26, 2023 come?
I'm not sure, Judge.
So we need to modify both judgments to reflect the dates reflected in the stipulation of evidence. Because they say January 26. So cause number CR 2390, the date of offense needs to be July 1st, 2022. And cause number CR 2391 needs to be July 16, 2022. All right, thank you.
I think I can figure out where the January. A lot of times the date of arrest is on the bill as the date of offense, I think.
Well, then they were. Be ready, Mr. Schmidt.
Judge, I have an announcement on Michael Covey, and then we'll be ready to proceed on Billy Schultz. So Michael Covey.
All right, see you there, buddy.
No, sir, that's the announcement.
Oh, he's not missing, is he?
No, sir.
All right, this is cause number CR 21-54 State versus Michael Shane Covey. Go ahead, Mr. Schmidt.
Judge, Mr. Covey is currently isolated due to mental health issues. And I've spoken with him today. I'm going to ask that he not be brought up. My announcement on his motion to revoke or adjudicate would have been a request for a reset. I've made him aware of that. So we'd ask that the court allow us to reset his motion to that October date.
All right, the court's going to waive Mr. Covey's waive and not require Mr. Covey's appearance today due to the mental health issues expressed by counsel. The court will reset today's motion to October 26th.
And we are ready to proceed on Billy Joe Schultz as well.
All right, Mr. Schultz, come on back up. Mr. Schultz, I can't remember if I swore you in, but I tell you what, I'm just going to do it all again. Go ahead.
Judge, the reason why I asked for a recall is that the state's motion to adjudicate contained multiple counts. A similar issue has occurred. And after reviewing the paperwork, the judgment reflects that Mr. Schultz would be pleading true to 2 counts on the state's motion to adjudicate, which would be counts 1 and 2. However, it's my understanding that there is a count 3, 4, 5, 6, 7, and 8, 9, and 10 on the actual official version of the state's motion. I've discussed that with Mr. Hartwell prior to coming back up, and it's my expectation that the state is going to abandon counts 3 through the rest. And we're going to plead true on counts 1 and 2, which is reflected in the judgment, and ask the court to follow the plea recommendation from the state.
And that's correct, Your Honor.
All right, so state's abandoning counts 3 through 8.
Yes.
All right, thank you for the heads up.
Yes, sir.
All right, Mr. Schultz, let's do this again. Raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court Be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, Jim, we're ready. All right, Mr. Schultz, you appeared before the board on February 22nd, 2022. You pled guilty to manufacture and delivery of controlled substance of yielding group 1 between 4 grams and 200 grams. The court heard the evidence that they found that there was enough evidence to convict you, but the court followed the plea agreement between you and the state. Court assessed your punishment at 8 years confinement. The Texas Department of Criminal Justice ordered a $2,500 fine. The court then suspended that sentence and placed you on community supervision for a period of 8 years. It was during that period that the state filed a solution to revoke, alleging 8 separate counts of various violations. Mr. Schultz, in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt's work?
Yes, sir.
But you've had enough time to talk to them about your case, have all of your legal questions answered.
Yes, sir.
Is there anything about the paperwork that you've read over and saw today that you do not understand?
No, sir.
Mr. Schmidt, you believe Mr. Schultz is competent in entering into this decision voluntarily?
I do.
All right, Mr. Schultz, the court understands the plea agreement to be that you're pleading true to counts 1 and 2 in exchange for the recommendation that your community supervision be revoked, that your punishment be assessed 4 years confinement in prison, and you being ordered to pay fines, restitution, court costs, and reimbursement fees that were previously ordered, and you get 198 days jail credit towards that sentence. Is that your understanding, Mr. Schultz, and what you want the court to approve?
Yes, sir.
All right, so at this time, Mr. Schultz, how do you plead to counts 1 and 2 as contained in the motion? Are those counts true or not true?
True.
You're telling me that those 2 are true because of the fact they are true. You're not
Yes,
just that, so you can get a plea agreement, is that correct?
Yes, sir.
All right, Mr. Schultz, Mr. Schmidt, any objection to the admission of the defendant's waiver of rights of plea attorney?
Objection.
All right, the court takes judicial notice of Mr. Schultz's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
No, sir.
All right, the court finds that the state has abandoned counts 3 through 8 in its version. Court finds that Mr. Schultz upon his plea of truth to counts 1 and 2. Court finds those violations to be true and finds that he has violated the terms and conditions of his community supervision. The court, following the plea agreement today, revokes Mr. Schultz community supervision, assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 198 days credit towards the sentence for the time that he's already spent in jail on this file. Mr. Schultz, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputy.
I believe that's all we have in here. Mr. Manning's going over paperwork with his final client.
Great,
So
so that's all from you, Mr. Schmidt.
That's all we need to know, yes, sir.
All right, great, thank you, sir.
Thank you.
Your Honor, on Cameron Roberts, he signed his amendment to his conditions to go into safety. So we've already taken him back to be booked in.
So did we already, we were set the date to amend, but he went ahead and signed it.
He was in agreement, so Ms. Burns had him sign.
Okay, and Mr. Manning was there, he's aware of it.
Mr. Manning said he was not any part, he didn't have any part in that
Okay.
negotiation.
He just showed up on the docket.
Yes, sir. He was to appear this afternoon to go into custody.
Gotcha, okay, I'll work him off, I'll know it.
So I think we're down to Mr. Ozuna.
Okay, all right, we'll stand and we'll wait.
Your Honor.
I hope you change your language.
Yes, ma'am.
And we are ready when you are.
All right, listen, I gotta get. All right, we are on the record calling for CR 22-385, CR 22-282, State versus Richard Ozuna Jr., Mr. Ozuna, if you'll raise your right hand and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can lower your hand. Mr. Ozuna, are you a United States citizen who reads, writes, and speaks English? And have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his work that he's done?
Yes, sir.
Anything about the papers that you've read over and signed today that you do not understand?
No, sir.
You understand everything you've read and signed, right?
Yeah.
Mr. Manning, do you believe Mr. Ozuna to be competent? And if so, that he's entering into this plea agreement intentionally, knowingly, and voluntarily?
I do, Judge. I have had quite the opportunity to meet with Mr. Ozuna several times for an extended period of time. During those times, he's been able to assist in his defense, ask pertinent questions, and seek clarification, even up until last Friday when I went and met with him. He was additionally able to negotiate this offer to receive this punishment. I think he did so intentionally, knowingly, and voluntarily.
Thank you, Mr. Manning. All right, Mr. Ozuna, in cause number CR 22-282, you are charged by, is it information or is it charged by indictment?
Judge,
Judgment says information, but I didn't think that was the case.
Judge, we're actually proceeding on 385, I believe.
I've got a dismissal on 385. I've got a plea on 282.
Judge, we have the opposite paperwork.
Really? Okay.
Let me double check. Hold on one moment.
They did change something here at once. Printed this before. When Stephanie's corrected.
Judge, I would state that I believe that the paperwork we have is correct. And 282 is a 2-count indictment that is being, that's the one that's being dismissed. CR 22-282, and we are proceeding on CR 22-385.
In CR 22-385, it is the aggravated assault deadly weapon against Mr. Brewer. Is that correct?
That is correct, Judge.
Say, do you agree?
Yes, sir.
All right, so let me back up. All right, Mr. Ozuna, in cause number CR 22-00385, you are charged by, let's go back to my original question, information or indictment?
Indictment.
Indictment, all right. The judgment's incorrect. It says information. It needs to say indictment.
Yes.
And Judge, on 385, I already requested that over lunch break, and it is correct on our copy.
It is correct on your indictment.
Yes, Judge.
All right. And soon to the second degree felony offense of aggravated assault deadly weapon. There is a range of punishment if convicted and sentenced, which would have to be not less than 2 years in prison or 20 years in prison, and a potential fine not to exceed $10,000. I see the plea agreement in your case is that you plead guilty to that crime in exchange for the state's recommendation that your punishment be assessed at 14 years confinement in prison with a $2,000 fine, $290 court cost, and 476 days credit towards your sentence for the time that you've already spent in jail on this cause. And the state would be dismissing cause number CR 22282. Mr. Ozuna, is that your understanding of the agreement?
Yes, sir.
All right, so at this time, Mr. Ozuna, I'll ask you, how do you plead to aggravated assault with a deadly weapon?
Guilty, sir.
Are you pleading guilty because you are guilty of committing that offense?
Yes, sir.
Has anyone threatened, forced, pressured you to plead guilty?
No, sir.
Right, court accepts the defendant's plea of guilt. Mr. Beatty, any objections to the stipulation of evidence?
No objection, Judge.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that, state has been in contact with the victim and they are supportive of this.
Thank you, Mr. Hartwell. Anything further from the defense?
Nothing from defense, Judge.
All right, then, Mr. Hartwell, I'd ask that you read, I don't have a copy of the stipulation. I'd ask that you read that, please.
Yes, Your Honor. On or about June 9th, 2022, in Van Zandt County, I, Richard Ozuna, saw Bryce Brewer driving his truck down the road where I live. I was angry at how fast Brewer was driving and told him to slow down. The interaction escalated and I assaulted Brewer. During the assault, I exhibited a glass bottle in a threatening manner.
Thank you, Mr. Hartwell. All right, based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Ozuna of this offense. Court will follow the plea agreement today. Court convicts him of aggravated assault with a deadly weapon, assesses his punishment at 14 years confinement. Texas Department of Criminal Justice Institutional Division orders him to pay a $2,000 fine, $290 court cost. The court orders 476 days credit towards the sentence for the time that he spent in jail on this cause. Court also finds the state's motion to dismiss the cause for CR 22-00282. Court grants that motion to dismiss. Mr. Ozuna, you hereby remanded to custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over for the deputy to be picked up. Mr. Manning, on the indictment right here, on his name is the word junior in the middle of his name. Does it say Richard Trio Junior Ozuna? Does it say?
On the indictment, it is not, the junior comes after, but let me check the judgment here I have. Hold on. Judge, on the judgment, it does follow and track the language of the indictment. The junior is afterwards, just as is displayed. This is 282, but it is displayed Richard Lutrio Ozuna Jr.
All right, great.
Judge, I believe that concludes my business. May I be excused?
Yes, sir. Thank you, Mr. Manning.
Thank you, Judge. Yes, it's. Yeah.
Mr. Stevens, are you ready?
Yes, sir.
Mr. McElroy, make your way up here. Mr. Stevens. And you can stay there if you want to, Mr. Stevens. You can just come up here to the table, it's fine. All right, this is cause number CR 15-00145, state of Texas versus Randy Lee Sheen McElroy. Mr. McElroy, you can raise your right hand, please your oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
There you go. Mr. McElroy, you appeared before the court on October 21st, 2014. You pled guilty to evading arrest or detention with a vehicle. The court heard the evidence that day, found that there was enough evidence to convict you. The court followed a plea agreement that day that you made the state. Court deferred a finding of guilt, did not convict you, placed you on 5 years of community supervision, and ordered a $1,500 fine. It was during that period of probation that the state filed in February 2019 its motion to adjudicate and revoke and alleged appeared to be a single count. Have you had enough time to go over that with your attorney, Mr. Bill Stevens?
Yes, sir.
Is there anything about the plea agreement and the paperwork that you've signed today that you do not understand?
Yes.
Mr. Stevens, do you believe Mr. McElroy to be competent, and if so, that he's entering into this plea intentionally, knowingly, voluntarily?
Yes, sir, I do.
And does your client waive the formal reading of the state's motion? And does he intend to play true to count one?
Yes, sir. Yes, sir, we do.
All right. Mr. McElroy, how do you plead to count one? Is that count true or not true? True. You know, you telling me that that count is true because what's alleged is in fact true.
Yes.
And Mr. McElroy, has anyone threatened, force, or pressure you to play true today? Yes. All right, the court accepts Mr. McElroy's plea of true to count one. Mr. Stevens, is there any objection to the admission of the defendant's waiver of rights of plea of true?
Yes.
All right, the court takes judicial notice of Mr. McElroy's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
Judge, my client, I've explained to you that he still owes financial obligations from, the original probation. He's asking if the court can waive any of those monies that he still owes, or perhaps reduce some of the monies that he owes.
And what's the grounds for waiver?
I make $1,072 a month in my school. I ran it down to 25. And I'm having to go get help on my water bill every month. And couple of times a month. Just try to make it and try to pay some else on this. I don't think I'm doing shit.
And I explained the alternative, Your Honor, if he didn't make the payments, he could end up back in the jail. Okay, this one.
What, I don't want to get into your medical history, invade your privacy, but can you tell me, do you have any type of medical issues that prevent you from working or doing community service towards discharging your bonds and corporate? Can you just tell me about some of your physical disability or inability?
My back is like terrible, and I can't my hands. I was going to put it off. It's going on this year. And my legs don't work. So
He's had like 26 surgeries. And probably more.
I just had another surgery last Thursday on my back. And I have to have another surgery in 90 days to do the other side of my back. It broke my back, broke my neck, cracked my skull, completely messed my legs up. That's not very good.
Understand. All right, thank you, Mr. McElroy. I'm gonna take that into consideration.
Thank you, Judge.
Anything else from the state?
No.
Based on the evidence today, the court finds that Mr. McElroy promised to be true that he's violated the terms and conditions of his community supervision. The court follows the plea agreement today. The court adjudicates the guilt of Mr. Smith on a lesser included offense of attempt to commit evading arrest with detention of the vehicle. Court finds that this is being punished under section 1244A as a state jail felony with misdemeanor punishment. Court assesses punishment at 16 days confinement in the county jail, awards Mr. McAvoy 16 days credit for time served. Court, in considering the previously imposed fines, court costs and reimbursement fees, or based on the evidence provided by Mr. McAvoy today, the court will waive the fines, court costs and reimbursement fees. Mr. McAvoy, you're invited to confess to the sheriff, so you can have the terms and conditions of the sentence. In just a moment, deputy here is going to come over here and take the thing. And then we can get you copies of this. Okay. Thanks, sir. I have to sign a separate order to waive your court costs and those matters, so give me a moment, while you're getting fingerprinted, I will get something printed up, and then that way you can have it for your records. Yes.